morning, ladies and gentlemen. We're pleased to be here today for the clause-by-clause review of Bill C-337, an act to amend the Judges Act and the Criminal Code, (sexual assault). We'll begin our clause-by-clause pursuant to Standing Order 75-1. The consideration of Clause 1 short title and the preamble is postponed. And so now we move to Clause 2. If you'll refer to the amendments that were sent out, there is a Liberal 1 amendment. I wanted to inform the committee that if Liberal 1 is adopted, then NDP 1 cannot be moved because there's a line conflict there. So just be aware of that. So Liberal 1 says that Bill C-337 in Clause 2 be amended by replacing line 28 on page 2 with the following pensive and education and sexual assault law that includes, and B, by replacing line 32 on page 2 with the following associated with sexual assault complainants, and 2, social context education. Discussion on the amendment.
So do I have to speak first because I moved it?
Yes.
I do. Okay, so I'm not actually going to, I guess I have to move it to have a discussion. But I'm going to turn it over to my colleague Sean, if that's okay, or if you could recognize him.
Mm-hmm. Do you intend to move it or not?
I'd like to have a discussion first, if we could.
Yeah.
Is that allowed?
If you want to move it, I think that's fine, Pam.
I can move it and then withdraw it if I want, right?
That's right.
Yeah.
Okay, so I'll move it, but I may withdraw it.
Okay.
So the motion is moved, or the amendment is moved. We'll have a discussion from Mr. Fraser.
Sure. Thank you very much. And before we get into the specifics of the proposed amendment, which I think Pam will probably still want to talk to, I wanted to say first to my colleagues around the table that this study has been an absolute pleasure to work with everyone on. I want to let you know from the beginning that we've had a meeting as our caucus. We are largely in support of this bill. We don't want to tear down any of the major provisions, and I wanted to kick off the discussion with that sort of good faith suggestion to let you guys know that we don't want to have a big fight about this issue that we all agree is important, and I think we all want to land in the same place. Pam, I know you'll want to talk to the reason behind your amendment, so I won't step on your toes. Because we've learned that Lib 1 would render null and void Sheila's motion if adopted as is, I want Sheila to let you know that we actually quite like where you were going with your amendment. And if there's an opportunity to collapse the piece that Pam's about to raise with what you're doing, which when I read the language, I think it'll simply be inserting the words social context education in the correct spot. But we'd entertain that, and I want to just make sure from the clerk's perspective that we do it in the correct procedural way. With that, I'll hand it back over to Pam to talk about the importance of her proposed amendment.
Thank you, Chair, and thank you, Sean. So our amendment we put forward because of testimony that we heard in terms of the social context and the need for the training to not just focus on the law, which is extremely important, but also the social context of the law. And we heard from, especially on our second panel, we heard that as it's worded right now, it's actually too narrow, and it doesn't include that social context. It doesn't include the realities of and the concerns that Canadians have about what's being trained right now. So as Sean said, we quite like Sheila's amendment. So the clerk can perhaps guide us on wording to get social context into number 2. My apologies.
Ms. Malcolmson?
Appreciate the spirit of collaboration around the table here, and my team has worked with the clerk to identify a way to amend the Liberal motion to include some of that social context. So my sense is that if we were to proceed as per the normal path, then I would move an amendment, and I'm ready to do that once the chair lets me know that the motion is actually on the floor.
Actually, yours will be a sub-amendment to the amendment.
Correct.
And you may move it.
So I propose a sub-amendment to Liberal 1, and that would be that Bill C-337 in Clause 2 be amended by replacing line 28 on page 2 with the following. And my sub-amendment is in sub 1, after the words education in sexual assault law that, I would insert the following new words, and this is mostly what is written in the NDP one. So the words are, has been developed in consultation with sexual assault survivors, comma, as well as with groups and organizations that support them, comma, and that includes. May I speak to that?
Yes, please.
Thank you. So the rationale is that we heard a number of witnesses testify that consulting women's organizations that have on-the-ground experience and experience with sexual survivors of sexual assault be able to formally inform the training of judges. We heard Madame Sabourin say, quote, I welcome the involvement and we want to do that at the CJC, working with the NJI to involve community groups in the development. Not consulting would be a very bad idea. We also had an overwhelming number of witnesses who have experience with supporting victims of sexual assault who said that they were never consulted. We had many experts from the community working hands-on with these issues who wanted to be involved. Jackie Stevens from the Avalon Sexual Assault Centre said that. Neka McGregor, Executive Director of the Women's Centre for Social Justice, said we must include the voices of those individuals who have lived through the justice system because it's their experience that is actually going to change the perception and the understanding. We also had testimony from Marilyn Lopez, the liaison officer. She said it's very important with these types of initiatives that the groups on the ground that have the expertise be consulted. I see it over and over again. These groups aren't consulted, then these projects are pushed forward, and finally they don't address the realities that victims or survivors face in sexual assault. And finally, Jeremy Diaz, Executive Director of the Canadian Centre for Gender and Sexual Diversity, said civil society should not be left out of the conversation. Step one is opening the doors so that they can engage with them in having that conversation. So the amendment, a sub-amendment that I propose would be to formally bring those organizations in to shape the type of sexual assault training that judges receive.
Well done. Any discussion on the sub-amendment? Ms. Vecchio.
Just a quick point that we are on board with that. I think that is a very solid amendment, and thank you for all the work that you, both parties, have done on it.
Discussion on the sub-amendment. Mr. Fraser.
Very much, Ms. Malcolmson. One just point of clarity. When I heard it read into the record, I was unclear if that was in addition to what was proposed in the First Amendment, or if it was the amendment.
It was in addition to what was proposed in Lib 1.
Okay, so when I'm reading it, I'm just trying to make sure that I have a full grasp on it, because where it picks up, it's sort of mid-word. So perhaps, Ms. Malcolmson, could you just read what the complete amendment would look like, including your sub-amendment if adopted?
Thank you, Chair. So if we look at Lib 1, and in your sub 1, which reads education in sexual assault law that includes, what we would, if this amendment passes, then what would be inserted after the word that, so your word sexual assault law that, after that you would insert my wording, which is has been developed in consultation with sexual assault survivors, comma, as well as with groups and organizations that support them. And that, and then we go back to your wording, which was includes.
Perfect. Thank you very much for the clarity. And if I can just add, I think this is a clever and well thought out sub-amendment that addresses both the concern of the voices needing to be heard in the training process, but also should remedy the concern that we heard from the Judicial Council about not sort of prejudicing the ability of a judge to make an independent, impartial decision by hearing expert testimony from someone that they've learned from. So I think I personally will be supportive. I don't want to speak for the rest of the committee, but thank you.
Further discussion on the sub-amendment? Ms. Demoff.
No, I just want to say as well, I think it's an excellent addition, and you know, combining it with the fact that we know that marginalized groups have been the impact on them is the intersectionality of sexual assault, and including that from the testimony we heard. I as well think it's an excellent addition.
Ms. Vandenbeld. If there's no further discussion, all in favor of the sub-amendment? Excellent. And then all in favor of Lib 1 as amended? Excellent. All right. So
there's no NDP
that's right. So now there's no NDP 1. So now we go to
as amended.
shall clause 2 carry as amended? All in favor?
That went too fast.
Okay. So because Lib 1 is adopted as amended, then we don't have an NDP 1. Okay, so then that means everything in clause 2 has been addressed that has been submitted. Are there additional amendments to be brought? Aha. Ms. Malcolmson.
So to replay our success on the first paragraph, same situation. I have a sub-amendment to propose to Liberal 1. Sorry, to Liberal 2.
We're not at Liberal 2 yet.
Oh,
we're still just finishing off the clause that the Liberal 1 was in.
First one. Got it.
All right.
Okay, I'm ready though
That's
for the
okay.
next one.
This is excellent training. This is only our second bill, so we're getting better. All right. So shall clause 2 carry as amended? All in favor? Excellent. Now we are talking about Lib 2. So I just wanted to inform the committee that if Lib 2 is adopted, then NDP 2 cannot be moved because of a line conflict as before. So we will start with the reading of Lib 2 by Ms. DeMoff.
I think it's Karen.
Submitted by Ms. Ludwig, sorry.
Thank you, Chair. So in terms of our amendment, it would be taking the first part, so establish seminars for continuing education of 35 judges, and then we're going to change that to establish seminars for the continuing education of judges, including in respect of matters related to sexual assault and social context. So we're adding in social context.
Discussion on the amendment, Ms. Malcolmson.
I have a sub-amendment to propose, and it it brings in the rationale that I was going to propose in NDP 2. So my amendment is following the word social context in the Liberal 2 proposal. I would insert the words, comma, that have been developed in consultation with sexual assault survivors, comma, as well as with groups and organizations that support them, semicolon. Now, as we just discussed in the previous motion.
Discussion on the sub-amendment. Mr. Fraser.
I have precisely the same wording written down on a page in front of me, so I think you'll find support from this side.
Ms. Ludwig.
Thank you. I support that as well. I just want to read into a couple of pieces of testimony. So, for example, Honourable Rona Ambrose said on April 4th, in response to the question about intersectionality, I'm open to anything that will provide judges with better training about gender-based violence. At the end of the day, I am sure all of you know this, judges are just lawyers who are appointed to the bench. They don't come with all the training. Reinforce that we're all on the same page on this one.
Excellent. Further discussion on the sub-amendment? All in favor of the sub-amendment? Excellent. All in favor of Lib 2 as amended?
Before we move to a vote, just a quick piece of discussion on the amendment. I know that we heard a wealth of testimony about the need to educate specifically on issues of intersectionality. To anyone who might be watching the testimony, we also heard from academics, specifically professors, I believe Koshin and Craig, who suggested specifically that references to social context would be specific enough to allow the training for the intersecting grounds of discrimination. So I want to make sure on the record that we're not ignoring that and have thought out why this wording is appropriate.
I think that's an excellent clarification. Any further discussion on Lib 2 as amended? All in favor of Lib 2 as amended? All right. And so because we have talked about Lib 2, we are not talking NDP 2 anymore. So now shall Clause 3 carry as amended? All in favor? Opposed? Good. Yep. Moving right along. Now we have NDP 3, and the ruling for this one is that it's not admissible. Bill C-337 amends the Judges Act to restrict eligibility for judicial appointment to individuals who have completed comprehensive sexual assault education. The amendment seeks to establish an education program for persons who play a role in the administration of criminal justice beyond the one that the bill contemplates for judges. As House of Commons Procedure and Practice Second Edition states on page 766, an amendment to a bill that was referred to committee after second reading is out of order if it's beyond the scope and principle of the bill. In the opinion of the chair, this amendment introduces a new concept that is beyond the scope of the bill. Therefore, I'm ruling the amendment inadmissible. Ms. Malcolmson.
I think it needs to be said on the record that the committee heard multiple testimony from a range of witnesses that the judge is the final person that hears the result of the extent to which sexual assault informs every other element of the judiciary and every other element of the justice system. And so we heard again and again that sexual assault and gender-informed and trauma-informed training should be available to the Crown, prosecutors, to police forces, to lawyers, to the judiciary, and that in order for victims to have confidence in the justice system, that they need to know that they're going to be treated with dignity and respect by all participants in every level of the justice system. So I just think it's important for the committee members to reflect that we heard that. The NDP proposal to amend was in that spirit, and I understand that we're trying through a private member's bill to fix a whole lot of problems throughout a whole lot of police forces, and so it's not a criticism to the drafters of the original bill, but this is a significant piece of work for which federal leadership is sorely needed, and if it can't be accommodated here, then I think we all need to take some leadership in pushing to find the place where it can be, where we can make this change. Otherwise, training judges will not have the effect that we desire.
Yes, I fully agree with your rationale and the need for this. It's just that it wasn't within the scope of the bill. So that's why the ruling was as it was. Any further discussion on that?
Yeah,
Ms. DeMott.
Yeah, thank you. Along with Sheila, I believe everybody at this committee would fully agree with you, but as indicated with the scope of the bill, I believe that this is a first step to democracy when it comes to those victims of unjust violence, and I think this is a great first step, and something like you've indicated could go on to another bill or another motion of something of that sort, but unfortunately I do not see it within the scope of what we did study. Yes, we did hear a lot about it, but it could be a recommendation after the fact, and once again, let's look at this as a very positive first step, working together to at least get judges started, and then we can grow from there.
Mr. Moff.
I think everyone was moved by the Crown Prosecutor who testified, Ursula Hendel, and I don't think I've heard more compelling testimony than hers. Having said that, so much of this training for police and Crown prosecutors falls within the provincial jurisdiction, and I completely agree that more needs to be done, and I can certainly say I've already been talking to my counterparts in the province of Ontario, but also with our Justice Department on how we can work with the provinces to ensure that they are working towards training Crown prosecutors, because as one witness, actually I think it was Ms. Ludwig said, it's the police and the Crown prosecutors that are down here. Judges are at the tip, and by the time it gets there could be a lot of mistakes that have been made. So I think we're all on the same page with you here, Sheila.
All right, so because NDP 3 is inadmissible, then shall Clause 4 carry as is? All in favor? Excellent. And now we will talk about NDP 4. And I would ask Ms. Malcolmson.
So my proposal is that Bill C337 be amended by adding after line 18 on page 3 the following new clause, 4.1. The Act is amended by adding the following after section 74. So 74.1 would read, the Commissioner shall, within 3 months after the end of each fiscal year, prepare and publish on the Office of the Commissioner's website a report on the education in sexual assault law described in paragraphs 3B, including any observations and recommendations that the Commissioner considers appropriate.
Discussion, Ms. Van.
Speak to it.
Sure.
The rationale is that we heard that there is a need for ongoing evaluation of the training for judges. And this could be in addition to the annual report that's referenced in section 62.2 of this bill. There are new cases every year, so that improving the training with new jurisprudence would be beneficial for the improvement of judges' training. And we want to make sure that there's a requirement that the training remains relevant, and the Commissioner could be the judge of that. And I'll leave it at that.
Very good. Ms. Vandenbeld.
Thank you very much, and I want to thank Ms. Malcolmson for, I fully agree with the spirit of what this is trying to achieve. One of the issues that some of the experts that we've consulted with raised is that the word website, because it isn't mandated by law that there be a website, it's very hard to then mandate by law that something be on a website because it doesn't exists. So I think that creates some difficulties with this. And actually, the report will be tabled in the House, and everything that's tabled in the House is made public. So this is actually already being achieved because of the fact that it is being tabled, it is being made public. It will be, presumably on the parle.gc.ca website. So I think that's already happening. And in order not to create some confusion in this, I think that it's probably best left to have it tabled in the House.
Ms. Demoff.
No, I'm fine.
The amendment. All in favor of the amendment? Opposed? All right. So now we move to Lib 3. And again, I would inform the committee that if Lib 3 is adopted, we cannot adopt NDP 5 because of the line conflict. And so Lib 3 is moved by Mr. Fraser, if you'd like to speak to it.
Certainly, I'll move the adoption of the proposed amendment Lib 3. Is it necessary for the record that I read it in, or is the written copy acceptable? Okay.
Written copy is acceptable.
Thank you very much, Madam Chair. So there's three components, essentially, if I can take our eyes off the language and explain them in more general terms to begin with, that are important here. Two are of a technical nature, and one is substantive. The technical amendments I expect will be easier for this committee to deal with as a matter of course, so I'll address them first. The first, which you'll see in Part A of the proposed amendment, is simply to achieve a coordinating amendment. Section 159 of the Criminal Code has been deemed unconstitutional. There's a bill before the House to actually remove it from the Criminal Code. This is simply to erase a zombie law that's been deemed unconstitutional from the books. I don't anticipate that'll be a problem, but I'll leave it to the members of the committee to object if they see one. The second portion or theme of this amendment is in sub 5 and also with respect to the word judge as opposed to court under sub A under the section 278.92. The reason for these proposed amendments is that under the common law, and I believe it's enshrined in the criminal code as well, there's not an obligation on a jury to produce reasons. By adopting this motion, we would be potentially running afoul of legal principles that I think we have no business interfering with. I expect this is something that if I were drafting this, I wouldn't have caught it, but when we ran it through some extra sets of eyes, this concern was raised, and I support it entirely. The third and perhaps trickiest amendment, and we had some conversations with other members of the committee, some department officials as well, and our legislative clerk, that might give us some problem here. But the substance of this issue is really about the requirement for written reasons. We heard compelling testimony actually from Professor Elaine Craig and Jennifer Koshan. I've actually studied under Professor Craig while I was in law school. And I appreciate the need for written reasons for two main purposes. One, the exercise that a judge goes through in preparing written reasons improves the quality of the decision. There's no question when you take the time to write something down, you think it through, you're less likely to make an offhand defensive comment, and I accept that. The second reason, in my mind, is really about the access to the interested audiences. I can think of a need for access to decisions for academics, for NGOs, for the press, for the litigants, of course, for the public at large, and for lawyers dealing with sexual assault matters that want to research the jurisprudence that's currently not being reported. The tricky part today is that if there's not a reporter sitting in the room, oftentimes these reports aren't made public. So generally speaking, I do support the requirement for written reasons. I do propose an amendment that is similar, I believe, in spirit to the amendment proposed by Ms. Malcolmson, which I'll address in a moment. But my concern about having a requirement for written reasons in 100% of cases has been borne out in one of the communities that I represent only weeks ago. In the small university town of Antigonish, Nova Scotia, we have seen what I believe is the first decision of its kind in my province, where a sexual assault charge against a university professor has been stayed under the Supreme Court of Canada's Jordan decision. If we specifically require written reasons in every sexual assault case, we will be adding a procedural step and presumably some additional delay specifically to sexual assault cases, which will lead to, presumably, more people who could or should be convicted of sexual assault getting out without ever having their matter go to trial. I expect that that is not the outcome that anyone on this committee wants, and it really becomes a matter of how do we address it. Ms. Malcolmson, through you, Chair, I initially took a shot at drafting this and had almost identical language about whether the court considers it in the interest of justice, well, the judge considers it in the interest of justice to do so. Upon further reflection, the interests of justice, in my understanding, is a legal term of art that can have a specific meaning in different sections of the law. For example, if you're considering whether to allow a third-party intervener to take part in litigation where they don't personally have an interest, there are concerns about whether they bring a new perspective, whether they have something of value to add. I have concerns that my initial thoughts as to the appropriate language, which are reflected in your proposed amendment, will lead to unintended consequences that we as a committee have not fully thought through and have heard no evidence on. So I took a shot at some, the best I could, at some plain language writing that would suggest that the reasons for a decision, despite the subsection requiring written reasons, the reasons for a decision need not be given in writing if the judge does not consider it practicable to do so. This would require, in my mind, that the judge make an assessment, and they have to decide it is not practicable for them to offer written reasons. The real reason I wanted to include this is really because of delay and the Jordan decision under the Supreme Court of Canada, because I think this will allow a judge to say, if this is going to literally let an accused person go free without trial, that's unacceptable, and if I can give an oral decision in shorter order to ensure justice is served, they will have the ability to do so. However, to protect against the potential trend that would see judges do this as a matter of course because they don't feel like it, I've inserted subsections 3 and 4 that says if subsection 2 applies, meaning if the judge decides they can give oral reasons, the court shall prepare a paper or electronic transcript. I've just said paper or electronic now. It's not actually in this, but this is something that I expect will need to be borne out in further discussion with the assistance of the clerk, of the reasons delivered orally or ensure access to an audio recording of the oral reasons. Then subsection 4, any written reasons given or transcript prepared under subsection 2 or 3 shall be entered into the record of proceedings. After a discussion we've had with a department official and briefly with the legislative clerk, what I really hope happens here, as someone who worked as a lawyer and relied on legal research tools in my career before politics, what I hope we land on here is an electronic site that we can search the decisions, even if they're not officially published in the way that written decisions typically are. we run into some serious difficulties if we require that a court develops a database because there's constitutional concerns under the Section 91-92 divide that put the administration of justice squarely within the purview of the provinces. If we require the provinces to spend money on the administration of justice in federal legislation, the clause could be struck down entirely as being unconstitutional and render moot the exercise that we're going through and the purpose of this proposed amendment. I suggest that the language I put forward may not be perfect, and if the chair would allow a brief suspension to discuss with members of the different caucuses represented here, the legislative clerk, and potentially a department official with expertise on this specific matter, I think the legislation would be significantly improved. So, Madam Chair, with your permission, I'd recommend we suspend for a few minutes to sort out the details.
I see there is agreement to do that, but I do want to just bring to the committee's attention that the amendment changes have only been brought in English, so I would need unanimous consent of the committee, since things are normally provided in English and French, to consider them only in English. Do I have the unanimous consent of the committee to do that?
It's just for distribution. We talk in
Excellent. Okay. Well, we'll suspend, and I'll look to you guys for an indication of when you've come to a conclusion. Excellent. And so we're back discussing Bill C-337 on the clause by clause, and we're fortunate to have as help for us today from our Justice Department, Gillian Blackwell and Uzma Isanula. And so, Mr. Fraser, back to you.
Thank you very much for indulging us with a brief suspension, Madam Chair. After a quick huddle with all parties and with the help of our clerk and with department officials as well, I believe if you see, you'll find unanimous consent to withdraw the motion that I've had on the floor and to introduce a new motion which we've had the opportunity to discuss, but will need to have further debate. So I would seek the unanimous consent through you, Madam Chair, of the committee to withdraw the existing proposed amendment, Liberal 3.
Do I have unanimous consent from the committee to withdraw Lib 3? I do. Seeing that, back to you, Mr. Fraser.
Now, I do have a proposed amendment, which doesn't have a fancy title like Lib 3. However, I will provide a copy in writing.
4?
Yeah, that's right. I will provide a copy to you in writing once I read it for the benefit of the crowd. And I believe the French version is available as well, but I handed my copy to another member of the committee. So once I perhaps read the English version into the record, I'll share both copies in writing with you and then have a few questions for our department officials. So the new amendment would read that Bill C-337 in Clause 5 be amended by A, replacing lines 21 to 24 on page 3 with the following. Reasons, 278.92, sub 1. In proceedings for an offence under Section 151, 152, 153, 153.1, or 155, subsection 160, sub 2 or sub 3, or Section 170, 171, 172, 173, 271, 272, or 273, the judge shall provide reasons for a decision that a person is, and then B, adding the following after line 30 on page 3, record of reasons. And this is really the key part that differs from the previous iteration. Sub 2, the reasons shall be entered in the record of proceedings, or, comma, if the proceedings are not recorded, comma, shall be provided in writing. And then similar to what we had previously, proceedings before judge, sub 3, subsections 1 and 2 apply only in proceedings before a judge without a jury.
Clerk now has
Okay.
And can we hear some commentary then from our Justice Department officials?
Thank you, Madam Chair. First of all, I would like to thank the honourable member for
proposing that the requirement for written reasons be replaced by language that is already reflected in the criminal code. It is reflected in 278.8 as well as 276.2 in regards to third-party record application hearings as well as rape shield application hearings. And they require either written reasons, or if those written reasons are not possible, that the reasons be entered into the record of the proceedings. And therefore, they would be made available, be clear for the parties and anyone else who's interested in having the information about how that decision was rendered. And that applies to the evidentiary provisions. However, the proposal here would have it apply to all of the sexual assault matters that are enumerated in this bill, and therefore would expand it without requiring written reasons in every case, which as noted, could have significant implications for effectiveness of the administration of justice, and consequently for these cases of sexual assault before the courts. So these provisions that exist already in the code have withheld constitutional scrutiny. They have been maintained. There is a desire to remain with existing language in terms of the standards for drafting in the code. As they've already been interpreted, it makes it easier to use the similar language within the code. They also remain within the Parliament, within the constitutional mandate of Parliament for criminal law and criminal procedure, and do not stray into the administration of justice by specifying exactly how the reasons would then be dealt with once they're on the record. And that, as we know, in the application of these provisions, they have been made available because the courts know that there is an interest in them, that there is a specific requirement for those reasons to be transcribed and available on the record. As a result, they are regularly uploaded onto CanLII, which is a free website with a database of over 1 million judgments and decisions from all of the Canadian courts, as well as laws, and that website is maintained through the Federation of Law Societies in collaboration with a private company.
Excellent. Thank you very much. We'll go now to Mr. Moff.
So I just wondered if you could clarify a couple of things for me. So everyone around this table and the drafter of the bill, what we want to achieve is, where possible, that we've got written decisions. We've heard testimony where, I don't recall who it was who said it, where they said where it's become public in the past, it's been because a reporter was in the room. And so that's what we're trying to avoid. And also so that there isn't a huge cost to the survivor or to the media or to anyone else who wants to investigate these decisions. So that's the end goal. So I understand from our conversations that you have very serious constitutional concerns about wording that we had put in, and that this would achieve our goal without, we are not allowed to force the provinces to spend money constitutionally, and the way we'd worded it in the past would have done that. So I guess I want an assurance that we're not, a new amendment would be constitutional, but it would also achieve the goal that all of us want, which is to ensure that written decisions are available and that there would not be a huge cost to people who are trying to access the decisions.
Good morning, Madam Chair. I understand the question to be whether the amendment as proposed will achieve the goal of the committee without straying into an area beyond Parliament's jurisdiction. The question here really is staying on the side of what is criminal procedure in these circumstances, and not straying into the area of the administration of justice. So the amendment that has been proposed now, that reflects other wording in the criminal code, has been upheld as constitutional, and the reason for that is that it stays on the side of criminal procedure, which Parliament does have jurisdiction over. To make it a requirement for courts administration to publish decisions would be to stray into the area of the administration of justice, And there is some very old and well-established case law that tells us from the Supreme Court that Parliament cannot require provinces to spend money within their area of legislative jurisdiction. And in a relatively recent case from 1982, that was in the context of the criminal code regarding a provision that allowed a judge to require a municipality to support a young offender while they were serving a sentence. It was struck down as unconstitutional because that was considered to be in an area in the provincial jurisdiction, and Parliament had no business requiring a municipality to be spending money in those circumstances. So I think the concern here that has been raised is that while we can require reasons to be provided in the record of the proceedings, and essentially that is an area of criminal procedure, so that what the provision is doing is saying that the record of this particular trial is not complete without a record of the reasons, whether they be oral or whether they be written. What happens after that is within provincial jurisdiction. Certainly court files are public, and when a transcript or written reasons are available, as Ms. Blackwell mentioned, there are private companies that pick them up and they are published. But it is beyond Parliament's jurisdiction to require that to be done by the courts themselves.
Very good. Ms. Vecchio.
Very much. And you mentioned that the site is maintained by CanLII. And I just want to get some clarification. Is that a public website, or is that specific to judges and lawyers only? Would anybody in Canada be able to access that? Secondly, if we're looking at this, and I totally understand where you're coming from, but one of my concerns is that if it comes to the provincial level, I realize that there's going to have to be a balance here when we come to the Constitution. But I think we recognize that there's access to information. That's another hurdle. So I think some of the times these hurdles, we do not want to put any of our, whether it's our media or our victims, whoever it may be, we don't want to have to put them at another hurdle with another cost. A lot of times these can be very expensive things as well. So we want to make sure that this is easily accessible and at very, very little cost, if any cost whatsoever. So first of all, if you can comment on CanLII, let me know about that. That may be the best opportunity or the best situation that we do have, but if you could continue from there.
Thank you. Thank you for the question. And indeed, CanLII is a free and extensive online search engine that contains over 1 million decisions from Canada's courts and administrative tribunals, as well as laws and regulations from across the country. It's a non-governmental organization, and it is funded by the Federation of Law Societies of Canada, which is the national coordinating body of Canada's 14 provincial and territorial law societies. So funding for specific projects are also sometimes provided by other levels of government as well. It works with a privately run company, Lexum. CanLII, when it started in 2000, was a bit of an experiment. There are private companies like Quick Law that cost money for access that lawyers have traditionally accessed. When CanLII made it, it's part of an international project for free law and access. So this, it has actually grown. It's extensive. It's publicly available. It's used regularly. The reports of its use and expansion, I mean, it's quite progressive.
So I right now would be able to go on CanLII and be able to pull up a thing. So any Canadian would have access to that.
Absolutely, absolutely. And in terms of the court record, I did just want to make it clear, when something is, an oral reason is recorded on the court record, it becomes available. So it's available at the court, and sometimes some places have certain photocopy fees, but those are more minimal. That's distinguished from the actual transcript. So if you want the transcript of the entire proceeding, those are usually through companies that are external. But again, the practice varies depending on the court. So having it available on the court record and then making that accessible, that would be up to the courts, but it's not the same in terms of accessibility as an entire transcript.
Very good. Mr. Fraser.
Thank you very much, and I sincerely appreciate your advice and information. To address Ms. Vecchio's issue regarding the cost, I understand that the cost of an actual transcript is in the range of 7 cents a word. So I think the likely solution is that at the provincial level, the folks making the decision on the mode of making accessible these decisions will likely get with the times and use an electronic version. I would hope, I think that would be preferred. I would suggest that it would be appropriate for this committee, if this amendment is adopted, to actually write to our provincial counterparts or different bodies that we identify. It doesn't have to take place in this meeting, and recommend strongly that they make these available online so anyone with an internet connection can access the decisions that currently might be recorded but not reported. I think we'd be on safe ground to make that recommendation as long as we're not trying to do it through the criminal law power and usurping provincial jurisdiction. So with that, I think I'm pleased to move to a vote unless there's further discussion on the amendment.
I have Ms. Vecchio on the speaking list.
If we're going to vote, fantastic.
All right, very good. Well, I think, Ms. Malcolmson.
Just as a heads up, we won't move forward with the amendment that we had proposed because Mr. Fraser's new motion captures it. But I just want, again, on the record to have the witnesses that came before the committee note that we heard them, and we heard from a great range of people that certainly pointed, whether they were representing victims or whether they were people on the advocacy and justice side, that the need for this is great. And I'll just say as well, we've had some delighted to see mainstream media reporting on the worst of the sexual assault trials that go sideways, but we also know that we have got less and less money in conventional publishing to actually go out and do that investigative journalism, which is a great cause of concern. So that if we're able to adopt Mr. Fraser's proposal, which has been guided us off the rocks a little bit by the Justice Department, so thank you for that teamwork, then it will respond to a need that's been identified on the record by witnesses, and we will, for the New Democrat side, be supporting.
Ms. Vecchio.
We fully support what the amendment that he's doing. We believe that this will have the best outcome. One thing I'd like to see actioned, as indicated by Mr. Fraser, is the letter that goes off to the provinces. And since we're going to be voting on this amendment and not actually that letter, what is the actions that we must take so that we as a group have decided that we will provide a letter to the provinces? I just want to know a little bit more on what the actions need to be taken.
I've taken a note to have that action. I don't believe we need a motion for that action. We've just given the instruction to the clerk to do that should this next amendment that we're about to vote on happen. And I want to thank our experts from the Justice Department for helping us, and I want to thank the collegial and cooperative spirit of this committee. And so with that, Liberal 4, as we will call it, no? Liberal 3, okay, the new Liberal 3, has been moved, and is there any further discussion on it? All in favor of that new motion? Opposed? Wonderful. And then I understand from Ms. Malcolmson then that NDP 5 will not be discussed. Mr. Fraser?
I believe we voted just on the amendment, but not on the clause, Carrie.
Oh, you're right.
Yeah, thank you.
I was about to get there. Yeah. So don't I have to address that this is off the list first? I'm just confirming, though, that NDP 5 we're not moving ahead with.
Yes, I will withdraw NDP 5. It's no longer necessary by virtue of Mr. Fraser's motion.
Right. And with that, then, shall clause carry as amended? Clause 5. All in favor? Very good. All right. Shall clause 6 carry? All in favor? Yes. Shall the preamble carry? All in favor? Shall clause 1 carry? Oh, no? Too fast?
Yeah.
All right, clause 1 is the short title. So shall clause 1 carry? All in favor?
how did we get to clause 1?
It's really the short title.
Okay.
So I think everybody agreed with that. Is that right? Just for clarity, all in favor of the short title? Yes, okay. And so then now, shall the title carry? All in favor? Good. Shall the bill carry as amended?
Point of order again,
Sure.
Madam Chair. I just, we voted for coordinating amendment number 6 a moment ago. I believe by virtue of Liberal amendment number 3, which removed 159, this may have caused, I don't know if that impacted how the coordinating amendment should have been dealt with.
So at this point, having approved clause 6, I would have to have your unanimous consent to unapprove it so that you can go consider it. So do I have unanimous consent to unapprove
Do we have
clause 6?
unanimous consent? I think it kind of slipped by on me, and
Is that fine? Okay, so
Okay.
now we can discuss clause 6. Mr. Fraser.
can I have just 30 seconds to have a quick discussion to make sure I'm understand what I'm about to argue
Absolutely.
here? Just thank you very much.
Yep.
As a result of Liberal Amendment number 3, which no longer included Section 159, the coordinating amendment has become unnecessary, I believe. So I would suggest that we actually vote against number 6. I think we were kind of going through quickly and sort of out of routine thought we were approving it. I did intend to vote against number 6, so the legislation makes sense given the previous amendment.
All right, and so the motion is to remove clause 6.
Yes.
You just asked the question.
Okay, he says, I asked the question, shall clause 6 carry? And if you don't want it to be there, say no.
Sorry.
Can I, as my father would say, can you say the funny part slowly?
Yes.
Yeah, that was way
So-
too abbreviated.
So basically, if we want to get rid of clause 6, then when I ask the question, shall clause 6 carry, you say no.
Okay, you were clear.
Yeah.
Mr. Fraser was not.
All right, Mr. Fraser.
That's right. I have that problem by times. So with respect to the section that dealt with written decisions, in my opening remarks on that proposed amendment, there were 3 things that it did. One was the piece about the substantive issue about written decisions, which we've discussed at length, and I think we're all on the same page on. The second had to do with dealing with jury trials, which was a technical issue that's still dealt with in the new proposed language. The third section was dealing with Section 159, which has been deemed unconstitutional and is the subject of legislation that will remove what I called a zombie law from the books. Coordinating Amendment number 6 seeks to do the same thing in a different and perhaps more complicated way, and it becomes unnecessary because Section 159 is no longer part of the section dealing with written reasons after Liberal Amendment number 3. Does that make sense, or is there am I still being unclear?
Almost, but I want to make sure that our conservative friends who are the shepherds of this, that it makes sense.
Yep.
Karen?
No, I see exactly where he's referring to, and I recognize through that that bill that Section 159 is being removed. So this is just a duplication of, redundant. Yeah.
All right, with that in mind then, shall clause 6 carry? All in favor? Opposed? Very good. And we return to our regularly scheduled program at, I think, title is where we were. So, shall the title carry? All in favor? Are the Conservatives in favor of the title? I'm assuming you are. Yes. Lovely. And then, shall the bill carry as amended? All in favor? Wonderful. And shall I report the bill as amended to the House? All in favor? Wonderful. Shall the committee order a reprint of the bill? All in favor? Wonderful. And we will try to bring this back to the House as soon as we can, tomorrow if possible, otherwise Monday. Ms. Moff.
So do you need a motion now for us to send a letter to the provinces?
I don't require a motion. We've given instruction to the clerk. If you want to make a motion, that's fine.
No, that's fine.
Yeah.
As long as she's got it, that's fine.
Yeah.
So who moved that originally then?
It was originally Sean that moved it, and all were agreed. I'll call it as a motion just so it's official. So the motion is to write to our provincial bodies to recommend an online access for these written decisions. Yes? Ms. Ludwig.
Well,
Online, but as well, it should be searchable so that someone's not getting a large transcript and having to read through it. They can actually search it, for example, for keywords.
Online and searchable. Okay. Ms. Malcolmson.
I find it a little strange for a parliamentary committee to write to provincial ministers. Is there consideration instead of us asking our justice minister to reach out to her provincial counterparts? That seems more ordinary and also probably more effective.
I'm open to suggestion. We did send the copies of the Taking Action Against Violence Against Women and Girls broadly throughout the province. We communicated directly that way, but Mr. Fraser?
I think it's a good idea. I think as well, perhaps what we can do is task the clerk with preparing a draft for our consideration, and we can think of who might be the recipients of this letter and feedback that it should include that we can deal with during committee business at our next meeting, or even potentially at the subcommittee. I think we're roughly on the same page, but if we want to go through our own justice minister, I have no issue with that. But I think the details of this letter we can probably sort out at subcommittee or during another meeting.
Right. So I'm going to ask the clerk to bring a draft for our consideration at the next committee business. And at the next committee business, we will craft the motion exactly as we would like to have it be, and then we will execute as such. Ms. Malcolm.
Thanks, Chair. 2 points. One is that the committee distributing a report that it has sent to Parliament is one thing, but in this case, we're actually taking on an advocacy area, so that's where I think minister to minister is most effective. I also want to make sure that we are going to capture the consensus I heard around the table that we've identified a need for sexual assault and trauma-informed training throughout the entire justice system, not only for judges. So if this remains the will of the committee, then maybe one letter could identify, both the publishing online of judicial reasons, but also the training for other members of the justice system, all in one letter that is intended to change provincial policy.
Yeah, I think that would be excellent. Comments?
I think it's fine. Yeah.
Very good. We do have some additional time, so while I have your attention, I want to tell you some exciting things that have been shared from the LEOC committee about upgrades to committee business in terms of social media. So, in addition to the Library of Parliament providing reports, instead of, the usual black reports that have the seal at the top that are incredibly visually stimulating, they will be able to put up to 3 pictures and a color band on our reports. So that is, quite exciting. And then they will also be introducing Twitter announcements for committees. So they will tweet out when committees are meeting. They will tweet out when there is a press release, and they will tweet out when there is a call for submissions. We are able to ask them to tweet anything else out, and we may retweet, and they will use hashtag FIWO as the tracker for that. So you'll see that rolled out. The other thing that's new is the parliamentary website is going to be updated, and it is actually a much better visual display, and accessibility will be very good. I don't know if you've had some difficulty trying to find things on the committee web pages, but they've made it much more friendly and searchable. So I saw those updates yesterday, and they will send us a presentation, which I will send along to you, but I wanted you to be aware that they are thinking about moving into the next century. I've also told them that 7 million people use Twitter and 22 million Canadians use Facebook. So I've encouraged them to get on Facebook and move our committees in that direction as well. Thank you to our wonderful committee today for your cooperation. I think, we've achieved an outcome here that was a recommendation from our report on taking action against violence against women and girls, and I think it is a good outcome.
Not necessary, thanks.
Right. Very good. With that, we are adjourned.